Hello, everyone. Dear delegates and distinguished colleagues, welcome to today's discussion on the draft amendments to Egypt's Criminal Procedures Code. It's an issue with far-reaching consequences for the protection of human rights in Egypt. These proposed changes have generated intense debate in Egypt and casting doubt on Egypt's commitment to upholding the human rights legal standards. Before we begin, I kindly remind you that no photographs should be taken unless explicitly permitted. Translation is provided for this discussion, Channel 2 for English and Channel 3 for Arabic instead of French. While legal reforms are often essential to address evolving societal needs, it is crucial to examine whether these amendments align with fundamental principles of justice and human dignity. Serious concerns have emerged, particularly regarding to the rights to a fair trial, freedom of discussion, of expression, and protection against arbitrary detention. Moreover, the potential for these reforms to disproportionately harm marginalized groups, especially political activists, journalists, and other vulnerable communities, demand our focused attention today. As our discussion today offers a platform to critically assess the impact of these reforms on issues like arbitrary detention, access to justice, and fair trial guarantees. It is also an opportunity to advocate for legal framework that not only safeguard national security, but also protect the rights and dignity of all citizens. Joining us today are distinguished experts who will share their insights on these draft amendments. And we will start with Mr. Ahmed Mifrih from the Committee for Justice, who will shed light on the legislative philosophy of the Egyptian regime, highlighting how the laws passed over the last decade have repeatedly violated international human rights standards.
Thank you, Maysa. Actually, in the last decade, the Egyptian government has passed a series of repressive laws that have greatly affected the state of human rights in the country. These laws were introduced as a part of the government efforts to tighten its control over the political scene and suppress any form of opposition, under the pretext of fighting terrorism and maintaining national security. These laws is, as example, the protest law, which adopted in 2013. This law, introduced in 2013, is the one of the laws that severely restricted freedom of assembly and expression. The law requires prior approval from authority to organize any gathering or protest. As a result, thousands of peaceful protesters were arrested, and the shrinking civil liberties in Egypt is happening since now. According to our data, because of this law, between September 2013 and the end of 2014, about 13,000 were being arrested, and there is and they are charged related to this protesting law in front of Egypt courts. Second law is the law number 136 of 2014, which we called the Public Facility Law. This law expanded the powers of military courts to try civilians in cases related to what the authority described as a public facility. Thousands of civilians have been tried in military court, which are known for lacking the minimum standards of justice. And according to our estimated data, between 2014 and early 2020, around 14,000 civilians were tried before the military court, with many receiving long prison sentences ranging from 10 to 15 years. The second law is the anti-terrorism law, which is adopted in 2015. This law is the one of the most impactful repressive law. It broadly the definition of terrorism to include even peaceful activities that criticize the government. This law has been used to prosecute thousands of activists and journalists. In 2022 alone, according to our data, about 25,000 were repeatedly detained under this law without clear charge or fair legal procedures, leading to widespread human rights violations. Other laws, the media and the internet laws. The Egyptian government has passed laws that restrict freedom of the press and expressions on the internet, including the press regulations law and the cyber crimes law. Under this law, hundreds of the media and the human rights websites have been blocked. Approximately 600 websites, while the government tools for internet censorship have been strengthened. And since this law is adopted, till today, the government is control the internet and control the the media in internet. The last law, and I think all of you know that who has followed the situation in Egypt, is the NGO law. In 2019, Egypt adopted the NGO law, which placed strict restrictions on the work of non-governmental organizations, including human rights groups. This law criminalized civil and human rights work in Egypt and limited their ability of NGO to receive funding and also to work in the country in many different ways. The impact of this law these laws have led to a significant deterioration in the state of human rights in the country, in Egypt. According to our report, as example, since the beginning of this year, just beginning of 2024, we documenting more than 1,450 violations, including arbitrary arrest, enforced disappearances, and the mistreatment in detention centers in Egypt. And the issue is, despite continued efforts to change these repressive laws in Egypt, the government now surprised the international human rights community by proposing a new draft law. This law to amend the criminal procedures law, involving more than, in this amendment, the government proposed 540 articles as amendment to the law that is already organizing the jurisdiction and the system, the justice system in Egypt. This move from the government can't be seen as a mere action, but rather as a clear message to all international mechanisms, especially the United Nations, where Egypt has participated in reviews of international agreements such as the International Convention of Civil and Political Rights, the International Convention on the Rights of a Child, and International Convention Against Torture. Although this international mechanism have repeatedly emphasized that the Egypt government is violating international standards through its repressive laws, the submission of the new law, this amendment, represent blatant disregard for all previous recommendations from these international bodies. The message from the government and from the Egyptian regime, I think it's clear that the Egypt government is not interested in doing any steps to reform this repressive law, and its participation in international reviews is merely an attempt to improve its image. Just that. Thank you.
Thank you very much, Ahmed, for this comprehensive overview that shed light on the various repressive laws passed in Egypt during the last decade that significantly restricted the exercise of basic rights of Egyptian citizens, and the figures you presented are chilling. So it is important to keep in mind as we move on into this discussion, this environment of repression that these draft amendments are being presented into. We will move now to our next speaker. Shahrazad Al-Hajjar is a legal researcher with the International Commission of Jurists, who will focus on how the proposed amendments undermine the right to defense and violate international fair trial standards.
So thank you, Mesa, for this introduction. I'll start by reiterating a point that was stated in the introduction. We are fully aware that Egypt's current code and practices have long been denounced by domestic and international organizations as well as different UN mechanisms. So when we are criticizing the proposed reform, if we can call it a reform, that doesn't mean that the current situation is ideal and reform are not needed. It's just that we are at a stage where the devil we know is more reassuring than the devil we might have to discover, as some examples given by my colleague demonstrate. I will first start by the issue of arbitrary detention. This is one of the points where the authorities claim to be bringing reforms that have been long called for by civil society. In fact, the draft Code of Criminal Procedure reduces the maximum period of pretrial detention from 6 to 4 months for misdemeanors, from 18 to 12 months for felonies, and from 2 years to 18 months for offenses that attract life imprisonment or the death sentence. But merely reducing the maximum periods of pretrial detention falls short of international standards. These standards are clear on the role the pretrial detention is supposed to play. It is not a sanction, but a preventive measure to ensure an effective and uneventful proceeding. As clarified by the Human Rights Committee, pretrial detention can be ordered only pursuant to an individualized determination that it is reasonable and necessary for such purpose as to prevent flight or interference with evidence or influence in victims and testimonials. It should not be ordered based on the period should not be ordered based on the potential sentence, but rather on the individual circumstances. This preventive objective and these conditions on the imposition of pretrial detention have absolutely not been reflected in Egypt's practice. In fact, it's quite the contrary. Pretrial detention has been weaponized and used as a punishment in and of itself, including against political detainees, and as a means to threaten and silence opposition. This has been denounced by several local and international organizations, including the ICJ, as well as by the Working Group on Arbitrary Detention, and completely disregarded in the so-called reform of the current code. The amendments do not do anything to curtail the broad discretionary powers public prosecutors have to order and extend pretrial detention without any independent judicial oversight in case falling under the counterterrorism law mentioned by my colleague. The current code allows the Supreme State's security prosecution, which is competent in cases under the anti-terrorism law, to order pretrial detention and for an initial period of 15 days, and to conduct review hearings and extend pretrial detention in 15 days increments up to 150 days, without any oversight from an independent judge. And this does not change at all with the proposed new law. When we think of how often this law, the counterterrorism law, is used against dissidents, the fear that pretrial detention will continue to be weaponized can in no measure be reassured by the mere reduction of pretrial detention regular durations. The draft also fails to tackle the Egyptian authorities' use of case recycling or tadwir, to extend pre-trial detention and unlawfully circumvent bail order by bringing consecutive similar charges against defendants, usually related to conduct for which a defendant has already been investigated. The UN Working Group on Arbitrary Detention has found that the practice of tadwir is incompatible with an accused's right to be tried within a reasonable time and the presumption of liberty pending trial. The draft also increases the risk of arbitrary detention by removing the requirement for public prosecutors to interrogate a detainee within 24 hours of initial arrest and detention. Under draft amendments, law enforcement officer must simply transfer the case to a public prosecutor within 24 hours of initial arrest, with no requirement for the public prosecutor to interrogate the detainee within this time, thus increasing the risk that detainees will be groundlessly detained for longer periods of time before their case is reviewed by an independent judge. The effect of the draft on lawyers and their capacity to effectively represent their clients are extremely worrying. In this draft, the prosecutors are granted the power to refuse lawyers the right to present defenses during criminal investigations. It also gives prosecutors vague powers to deny lawyers access to a client's file if deemed necessary for the investigation, without any clear criteria on what is necessary or unnecessary. The draft grants prosecutors the right to deny defense lawyer access to the investigation files ahead of interrogation and confrontations. It also gives the investigative judge, it actually transferred the power of the investigative judge under the current code to public prosecutor to refuse lawyers' requests to cross-examine prosecution witnesses during trials. The Human Rights Committee has stated that the right to equality before the courts and tribunals also entails equality of arms, which requires the same procedural rights are provided to all the parties. By granting the power to prosecutors to ultimately deny defendants' lawyers the right to question prosecution witnesses, to access files and make representation during proceedings, the draft placed prosecutors as parties to any criminal case in a privileged position relative to the defense, with the capacity to hinder defense lawyers in their preparation and presentation of cases. Consequently, these amendments would further pave the way for violation of Egypt's international human rights obligation, including to guarantee defendants the right to equality before the courts and tribunals. These measures are extremely concerning, as Egyptian lawyers are already submitting to incredibly difficult working conditions when they are not themselves the object of criminal pursuits and harassments by the authorities. However, the proposed amendments are certain to further complicate their job and therefore hinder the right to receive effective counsel. The draft amendments represent a considerable accumulation by prosecutors of power ordinarily invested in judges, contrary to international standard on the role of prosecutors. Some of the examples I've already mentioned during this presentation. For example, in the current code, it's the investigative judge who retains the right to decide on the admissibility of defense when questioning of prosecution witnesses. However, under the draft, the power rests solely with the prosecutor. The powers given to prosecutors in terrorism case remains unchanged. The draft codifies the existing prohibition in Law 71 on the prohibition of transmission of broadcast of session proceedings except with the written approval from the court president, thus undermining Article 187 of the Egyptian Constitution, violating defendants' right to public trial as guaranteed by the ICCPR, and stymieing the means by which lawyers, journalists, and civil society members can hold Egyptian authorities accountable for this violation. If the authorities were sincere in their displayed or advertised will to reform, this would have been a law to go back on instead of reaffirming in this new code. These only constitute a sample of the dozens of violations contained in the draft code. Detailing every single one of them would unfortunately, take time we do not have today. As an ending note, I will just add that we should not underestimate the Egyptian authorities' creativity in using the cover of reforms to find new ways of violating human rights. From claiming that this law is a positive reform of pretrial detention to using digitalization to create more distance between the lawyers and the defendant through the adoption of remote investigation and trial procedures, this draft is an unfortunate example of how a reform can be a double-edged sword. Thank you.
Thank you so much, Shahrazad, for exposing how these cosmetic changes fall short of international standards on pretrial detention and the way it is being weaponized to crush dissent. The undermined capacity of lawyers to present the defendants is worrying and undermines an important pillar of fair trial. And this fragile situation of the defendants is worsened in case they are victims of torture, which will lead us to our next speaker, who will, Giorgio from the Danish Institute Against Torture, who will discuss how these reforms contribute to a culture of impunity, particularly regarding the victims of torture.
Thank you, Maisa. Thank you to the previous speaker for setting the issues that are relevant when it comes to the legal framework. So why I was asked to reflect on how this draft can impact by sort of positive action or just the lack of it, the protection of people from being tortured. First of all, by setting briefly the scene of the issue of torture in Egypt is not something that can be sort of treated lightly. A reform of the Code of Criminal Procedure must take into account anything is possible to start preventing and creating a legal framework where the risk of torture is contained and prevented. Unfortunately, this draft that we are examining falls very far from doing so. Why it is important to address so urgently the issue of torture in Egypt. The issue of torture in Egypt, by now it belongs to the modern history of Egypt. We know that in 1996, so we're talking about almost 30 years ago, the Committee Against Torture, that is the highest body in terms of reputation and competence, activated a special procedure targeting Egypt because the number of torture cases reported was high and concerning and considered to be systematic. Almost 20 years later, so we're talking about recent history, in 2017, there was a second special inquiry by the Committee Against Torture, again addressing the systematic use of torture by Egypt. During this period of time, in 2011, we had, as we know, an uprising in Egypt where one of the main slogans and cases that led to the revolution was the case of Khaled Said. Khaled Said brought many people to the street where everyone was saying, we are all Khaled Said. Khaled Said was brutally tortured in public area with his face brutally smashed on some concrete stair by police officers, because that was the culture allowed to police officers in Egypt. We know that Egypt had issues related to its foreign affairs that were affected by the predominant use of torture that went and affect an Italian citizen, Giulio Regeni, whose case has been, as we speak, tried in Rome by independent judges, Italian judges, after a long period of investigation, where 4 high-ranking officials from Egypt are being investigated for cases of torture. There was a case of enforced disappearance, torture, and murder of an Italian citizen, Giulio Regeni. So the issue of torture is an issue that is urgent. And Egypt cannot afford sort of postponing or missing opportunity to address clearly ways to prevent it. We always think that prevention is better than punishing a perpetrator. Punishing perpetrator, of course, is important. It's part of the rights of the victims to access redress, which an important part of redress is the punishment of keeping perpetrators accountable. But more wisely so, especially when torture is widespread and systematic, the state that is honestly interested about improving its record and improving the life of many citizens is to start engaging into preventive issues. Now, the current code, in the way that we've seen it, fails to do that. We heard that on some aspect, it creates additional problem. It creates, for instance, it enlarges the gray area around arbitrary detention. Whenever there is arbitrary detention, the alarm bell for torture rings very, very loudly because the persons that are arbitrarily detained are not kept under the control of independent authorities such as an independent judge. Now, the issue of Article 40, where the person needs to be brought to the attention of the public prosecutor, but the public prosecutor has no time limit to investigate him, that is very, very scary in a situation where we already know the torture is most likely happening already. So postponing any time where there is a check and balance between the different authorities of the state increases dramatically the torture that most likely is already happening. We know that the draft, as we read it, fails to make mandatory the monitoring of places of detention by different bodies such as prosecutor, independent judges, and so on. It keeps it discretionary. Now, the conditions of places of detention in Egypt is dramatic. We have documented dozens and dozens of cases, including the former President Morsi. We mention him simply because it's an outstanding sort of piece of history where a former president dies out of medical neglection in prison. The medical neglection in prison is done systematically so that can be considered done on purpose as a means of ill treatment and torture, often leading to death. In one way to avoid this from a wise country will be to create a mechanism where there is an independent monitoring that, even without sort of seeking accountability, creates a system that there can be a bit of a control so that prison, the authorities between themselves can enter into a positive dialogue so that condition of detention can be monitored in a preventive manner, there is dialogue, there is improvement, without necessarily jumping on accountability. Of course, we are all for accountability, but before jumping on accountability, we can start addressing torture by preventing it. Again, this draft code totally ignores this type of problem. One other article that is particularly important is, for instance, the Article 210 and 232 of the draft that, again, do not act on the right of victims of torture to seek a legal action directly in front of a judge, but it leaves the authority to the public prosecutor, where since before 2011, it has been documented as the stumbling block to activate accountability for perpetrators of torture. So the issue here is that I'm obviously not a particularly sort of illuminated person or intelligent. I'm telling you all these things. I mean, these possible reforms are out there everywhere. Since I have memory of producing recommendation on the issue of torture to Egypt in the previous UPR, the Universal Periodic Review, in the upcoming UPR, because we already submitted a multi-stakeholder report, in a report to the CAT, we make always the same recommendation. Please act on legal reform so that this and that can be improved, so that you can be in a better position to prevent torture. So Egypt knows that. Egypt knows exactly what are the problems. So in the moment that you put in practice yet again what we then have to value as a cosmetic action, then we are particularly disappointed and somehow frustrated on behalf of the many victims, on behalf of a country that could improve but does not improve. So we will, again, sort of ask Egypt not to embark into this reform, but to wait, go and analyze the different recommendations that they have received, and try to capitalize on this opportunity that, unfortunately, a reform of the Code of Criminal Procedure does not happen every second day. No, as we heard, there are like 500 plus articles being reviewed. It's a massive undertaking. There are other countries in the region that are taking responsible steps to reduce pretrial detention, to activate non-custodial measures. You see examples in Morocco. You see examples in Jordan. I'm not saying that there's no torture in Morocco, there's no torture in Jordan, but they're taking steps to prevent it. Egypt is not. Why Egypt needs to be like one constant black sheep into all this? So when the problem is very much acute. So I leave this with a question. Of course, it's a rhetorical question, but I will be happy to address any clarification later on.
Thank you, Giorgio, for describing how this draft law, as presented, fails to install the guarantees to effectively prevent torture via effective independent monitoring of the conditions of detention. We will move now to our last speaker, Mu'taz from the Egyptian Human Rights Forum, who will address the impact these amendments will have, if adopted, on the situation of the human rights defenders, and what the future may hold should these changes be enacted.
Thank you very much. The level of damage in Egypt law and the institutions is alarming. This code is just one example, but since 2014 we have hundreds or maybe thousands of legal amendments that really reshuffle what we know about rule of law in Egypt. This is the first point that we need to keep in our consideration. This code will legalize practices that already prevailed in Egypt over the last decade. There are new aspects of this code, as my colleague explained, but there are other aspects that just replicate the reality. It just be legalized in a code, but it already practiced in Egypt. How it is practiced, in my view, there is complicity between the three pillars of judicial system in Egypt, or the justice system, criminal justice system in Egypt. Law enforcement, member of law enforcement, the police or the security service. Second, the prosecutors, the general prosecution. Third, the court. And this is unfortunately because long time ago we were talking about margin of independence in Egypt judiciary. Now we are talking about a new judicial system, and the International Commission of Jurists published an important report in 2016 on how judicial system has become an instrument of repression in Egypt. I really recommend that you read this report because it gives us indicator that even if President Sisi withdrew this bill, in my view, nothing will change because already the institutions right now in Egypt practice everything: travel ban, declaring individuals, innocent people on terrorism list, asset freeze, pre-trial detention, complicity in forced disappearance. This is something very normal, and anyone following Egypt will be aware of that. So the three pillars of justice in Egypt are working in harmony. And here I give you some examples, and these examples are relevant to the human rights defender, the situation of human rights defender, but just to see how violation and a grave violation committed under the consent of the judiciary and the prosecution. We have, for example, Professor Ahmed Al-Tuhami, doctor, he is professor of political science. He spent pre-trial detention now more than 4 years against the law, and the court did not object. He attended the session, and the judge just renewed detention. And what are the charges? Belonging to terrorist organization, spreading false news, this kind of standard accusation that is repeated in many other cases. Another case, for example, two movie stars in Egypt are well known, Amr Waked and Khalid Abu Naga. Both of them, because of some activities with the Egyptian human rights community, including the Egyptian Human Rights Forum, they were removed from Egypt Actors Syndicate. They went to the court to challenge the decision. I have here the judgment made by Court of Administrative Justice in 2021. The judge just said both actors, they have bad reputation because they attended a hearing session in United States on human rights situation in Egypt in collaboration with an organization, Egyptian Human Rights Forum, and they are working against Egypt national interests. This is the judge who says that. Traditionally, Egypt State Council was important for victims of human rights in Egypt. There were lots of important and positive decisions came from this court, but imagine that a judge saying that. Another case, Bahid Din Hassan, the director of Cairo Institute for Human Rights Studies, when he received 15 years in abstention, the judge, when he was saying the conviction, he actually did a political speech. It's not a law, political speech, accusing Bahid Din Hassan, one of the figure of the Egyptian human rights movement of being a spy, of being someone who work against Egyptian society and religion. I don't know why he inserted religion in his speech, but even the speech is available online. You can look at this and hear what he was saying. Many other examples. Recently, we received a complaint from a lawyer, an Egyptian female lawyer. Her brother was under forced disappearance for 5 years. We don't know anything about him. 5 years. His name is Ahmed Hassan Mustafa. Okay? She sent complaint to the prosecutor. Nothing happened. So the prosecutor has the power to investigate. He didn't do anything. So these violations are committed under the approval of the prosecution and the judicial system. And this is actually just, invite us to think about how court can facilitate repression in any repressive situation. Egypt is a case study right now. So the code, the criminal procedure code will normalize this situation, and it will add new aspect which will affect Egyptian human rights defenders, including, of course, the Egyptian community in the diaspora. Transnational activism is important in Egypt right now. It is the only resistance to Egyptian repressive regime, because inside Egypt it's totally restrictive, and it's very dangerous for people to engage in independent activism. The question now, this code will facilitate repressive and reprisal measures against human rights defenders, including denial of document of identification. This is something systematic implemented by Egypt. Consular service are not being offered to human rights defenders and political activists outside Egypt. This is very systematic, and some of them turn it into stateless, or of course they have to seek asylum in European country. But some of them are living in countries that do not have legal protection for refugees. So they are really under serious risk of deportation back to Egypt. Asset freeze will be just decided by the prosecution. In absentia conviction, this will be very easy right now, and we already have lots of cases. My colleague, one of co-founder of the Egyptian Human Rights Forum, he was convicted 25 years in prison. He's outside Egypt, he cannot return back. And when Egypt started the national dialogue and discussed this presidential pardon, they just neglected the situation of hundreds or maybe thousands of Egyptian activists who are living outside Egypt and need also their right to return. They need to return in a safe country. They need to return to be able to work and to work independently, not to be compromised, because there are conditions. You could return to Egypt and you could be safe, but on condition that you support the government, you participate in the national dialogue, you give consent to legitimacy of the practice that is happening in the country. Another point also that we need to be aware of the deception of law in Egypt. When the government talk about legal reform, we need to be very much careful, because we had lots of examples. In 2017, we have the NGOs law, draconian code. It was withdrawn by President Sisi. Then another code implemented in 2019, but nothing happened on freedom of association. Still, NGOs are massively restricted. We cannot, these organizations that are on the table cannot register or work freely in Egypt. Impossible to be registered in Egypt. So we have to be careful about this kind of legal reform. And it is an irony that now the government proposed this code just a few months before the UBR. Imagine, usually before the UBR, you do some kind of even cosmetic reform before you come to Geneva. But also tell us something that the government doesn't care about it, because they know that they are well protected. And let us be frank about that. International actors started to be a little bit disregarding, or to disregard the situation in Egypt. And this is actually send a message of empowerment and protection to Egyptian human rights violators. So this is an appeal that we are making here in Geneva before the UBR session to hold the officials accountable during this session. Last point that I'd like also to discuss is that right now the question of impunity is common and prevailing in the country. The prosecution actually does not conduct its duties. lots of complaints received by the prosecution from human rights defenders, from family of human rights defenders, and they are not acting. They don't do anything to investigate the human rights violations that is being systematically committed in the country. This code actually will increase the climate of impunity in the country, and it will make the life of lawyers much more harder. Already lawyers, they are suffering in Egypt. Lawyers and human rights defenders, they are suffering in Egypt. But this code will make their life much more harder. They will not be able to conduct this work. That's why today in Egypt there are some kind of resistance to this law. There is some kind of resistance played by journalists and independent lawyers, but they need the support of the international community. It's very important to act quickly before this code is adopted, because if it is adopted, it will be hard to amend. And actually, if this adopted, it will actually, as I said in the beginning of my presentation, it will rationalize, legitimize the current practice, and it will be under the name of the law. Thank you.
Thank you very much, Mu'taz. We now move to the floor to receive any questions or comments. Yes, please. Sorry, can you also present yourself?
Okay, thank you very much, and good morning to everyone. And my name is Muhammad Saleh Muhammad Yassin from the African Center for Democracy and Human Rights Studies, and activist in human rights. Thank you for this panel and all our support and solidarity for the NGOs, which has reflected the serious human rights situation in Sudan and the danger to work in this field in Sudan. And also our solidarity and support to the colleague who reminded us of our connational Regini, victim of the torture, and still his people, in his relatives in my country, or second country and nationality, in Italy, waiting the justice for that. It is good the question, the issue of the prevention highlighted by our colleague Giorgio. But also here, bringing this here to the forum of the human rights is an important issue, because the state is claiming that and trying to whitewash and improve its image and as a leading figure in the defense of the human rights, while the reality is totally different. And this is happening through the repression and the closure of the civil space for the human rights defenders and the activists in these fields. Important issue which I would like to address here and highlight also, because I witnessed this during a recent visit to Egypt. You know that Sudan and Egypt are neighboring countries, and their history is common. There are millions of Sudanese crossed the borders and went to Egypt, and most of them, they are asylum seekers. They are requesting for asylum seeking, and they are asking for their natural life, natural rights of life, leave the other rights of social or economic rights. And the recent report of Amnesty International about or regarding the refoulement or the return of some people to Sudan is alarming. I invite everyone to read that report extended by Amnesty International. Unfortunately, some of these people who are sent back are sentenced to death. And now more than 300 are jailed in Port Sudan, facing serious sentences of death of false accusations based on the same accusations of terrorism mentioned by Mu'taz and that things. So we have to raise up our voice and work seriously, and also tell the country which is claiming to improvement of the human rights and making these cosmetic activities that the reality is this. It is good that when they come to the UPR, tell that we have done that, and that. But when we face them with the facts on the ground, this is going to at least tell them that the scene is not only for them. These are the points which I wanted to express. And also another something which I would like also to mention, that when you also condemn the occupation, you don't be an occupier. They are condemning the occupation in Palestine and Gaza while they're occupying Triangle of Sudan. This is, I know this point this is not the right forum to address it, but we are keeping it in mind and we will remain vigilant for that. Other issues of other complexity, don't want to add it here, but I would like just to thank you for this side event. Thank you very much.
Thank you for your testimony. Yes, please, and then.
اوكي، المحامية رنا دبليس، مديرة معهد حقوق الإنسان بنقابة المحامين بالشمال بطرابلس لبنان. كمان أنا مدربة قانونية مع CRTDA ومراكز مركز البحوث القانونية. بالواقع اليوم أنا بلاقي المقاربة كتير صعبة، لأنه الدولة المصرية عم بتغطي الانتهاكات بأسلوب تبريري عالمي، إنه أنا عم بحمي حالي من الإرهاب، وهيدا الشيء بيعزز لها موقفها. بنفس الوقت اللي قاعد بقلب البلد مش قادر يقاوم، لأنه هو تحت سيطرة الموضوع وهو ما رح يقدر يعمل شيء. عم فكر، أنتوا عم تحكوا، عم فكر بالاستراتيجيات العملية اللي ممكن فعلا تكون نحن نشتغل عليها، أو إنه نحن نتساعد لنشتغل عليها، لأنه ما فينا نحكي عن المشكلة بدون ما نقول عن الحل. إنه إذا حكينا بالمشكلة كل الوقت وبعدين لوين بدنا نوصل؟ فأنا بلاقي اللي هن قاعدين خارج الأراضي المصرية مفروض يعملوا لوبي ضاغط خارج مصر، يقدروا من خلاله يعملوا الضغط ويبينوا أكتر هالانتهاكات. نحن مثلا بلبنان مش واضح عنا هيدا الشيء. نحن بلبنان طبعا نحن غرقانين بمشاكلنا، بس المشاكل هلأ اللي عم بسمعها بشكل حقيقي ما كتير مضواية إعلاميا. يعني أنا اللي بطلبه منكم لازم تكونوا متضامنين برا أكتر، وتعملوا لوبي ضاغط بطريقة إعلامية ممنهجة. تقدروا أول شيء تسلطوا الضوء بشكل أساسي على قوانين اللي هي مخالفة لحق الدفاع المشروع، مخالفة للإعلان العالمي لحقوق الإنسان، مخالفة لكل الاتفاقيات الدولية اللي هي مفترض أنها تكون ضمن مطبقة بمصر. فأنا بلاقي أنه لازم نحكي بالحل.
I'm sorry to cut you off. It's just we have only 10 minutes left. So if you can go straight to your question, or we can move to our panel. Okay.
خلص.
شكرا. Do you want to answer, or should we move to other questions? Yeah, let's move to Samad.
Okay. It wouldn't be like a big question, more or less it's like a small comment on what all the speaker has been like thoughtfully actually explaining to us about the criminal procedure law. I think this code or this law, in addition to arresting journalists in the past 2 months, is in addition to enlisting human rights defenders on new cases that they don't even know about, is a clear indication that what the Egyptian regime is trying to promote right now as national dialogue and as reform is actually a burlesque reform process. And that in addition to the point that I cannot recall the name, but the Mrs. over there was saying that about the organizations or the defenders in abroad. Actually, although we are abroad, we are not out of touch. We're still victims and subjected to transnational repression practices. We're subjected to acts of reprisals. Several defenders has reported arresting of their families or security threats to their families because of their activism in the diaspora. We have also reported even 2 months ago here in Geneva, one of our colleagues, a human rights defender, she was followed by security agents here in Geneva, and they intimidated her. So although we're out, but still we're, and as Mu'taz was saying, we are subjected to different practices. We're deprived from consular services. There are digital repression and digital attacks all the time in organizations trying to hack them or to leak them. The several organizations and several defenders in the organization has been enlisted on terrorist lists in Egypt, and this has implications even in their lives in the new homes. Actually, what the director of Cairo Institute has an absentia verdict against him, 15 years in jail. One of our founders has 25 years absentia verdict against him, and this is all because of their activism. I'm sure everyone, like Ahmed and other, has been subjected to different practices, and we'll all do some kind of self-censorship in a way because we're afraid about our families back home. Thank you, and I'm sorry I'm taking a lot of time.
Thank you so much, Summer, for this important testimony. Yes, quickly, and then we move to concluding remarks by the panelists.
To what extent, this is a specialized case, this is a specialized area. But we have in the world internationally now a huge public voice for freedom, either for Palestine, for Sudan, etc. To what extent can this voice be used in solidarity with Egypt, and to what extent can this case for Egypt be put on the global agenda since we have the fora now? Thank you.
I wanted to say something about what we can do. There are two directions here. First one is resistance, and this is one form of resistance, but of course we are working tirelessly to raise the awareness of the impact of this law. The level of documentation and reporting on human rights violation in Egypt is strong, and this is also an indicator of an active human rights movement. Despite all repression, the human rights movement survived. There is a high level of resilience, and it worked. Another direction also, when the government declared the national dialogue in 2023, we actually were among the actors who engaged in the beginning. In 2023, there was a statement made by, signed by more than 500 Egyptian activists inside and outside Egypt. And we asked the government to impose or to adopt some building confidence measures before starting the national dialogue. And some of the activists outside also, they requested to be represented in the national dialogue, but the government just disregarded that. Because they have a plan. I mean, what we will be misleading if we read what's happening in Egypt as a political reform or a political will to reform. No, it is just dynamic, especially, for example, when the United States starting to discuss military aid to Egypt. Just the government try also to do something in order to secure the military aid. If the United States decided that it will not impose any conditionality on Egypt, repression will increase in Egypt. This is what happened really over the last few years. International actors' performance influenced the situation in Egypt. When the Human Rights Council did statement, members of the Human Rights Council did a statement, collective statement, in 2021 on the human rights situation in Egypt, Egypt also published the strategy, human rights strategy. They established the Presidential Pardon Committee, and they released some political detainees. The international dimension is very important in Egypt and what's happening in Egypt. Thank you.
Thank you very much. I wish you all the best, but I remember that in this court, because this court and because what's by say in this court, he sentenced to 15 years. In your chair, he stayed in your chair, by the way. So I wish you all the best, by the way. But yes, I think the most important thing is now the strategy of the interact of the international society regarding the situation in Egypt. I believe that it must reconsider the international community to re-strategize their way for dealing with the Egyptian government. I believe the current, what is called open dialogue approach, or that soft diplomacy, now it's not a part of the dealing with the situation in Egypt. This is our historical acknowledging or experience regarding the situation in Egypt. I hope the international society, UN mechanism, and others using another different strategy regarding the situation in Egypt to help the Egyptian human rights movement, and also to improve the situation of the human rights situation in Egypt. Thank you.
Thank you, Ahmed. And with this recommendation, we end our side event. Thank you for being here today.